Good afternoon, everyone. This afternoon, I will be discussing Rule 71, Sections 1 to 3. Rule 71 talks about contempt and the definition of contempt of court. This this was discussed in the case of Regalado versus Go, which will be uh, tackled later. Contempt of court is a defiance of the authority, justice, or dignity of the court. Such conduct as tends to bring the authority and administration of the law into disrespect or to interfere with or prejudice parties, litigant, or their witnesses during litigation. It is defined as disobedience to the court by acting in opposition to its authority, justice, and dignity. It signifies not only a willful disregard or disobedience of the court's orders, but such conduct as tends to bring the authority of the court and the administration of law into disrepute, or in some manner to impede the due administration of justice. Contempt proceeding has a dual function. The first one is vindication of public interest by punishment of contemptuous conduct, and coercion to compel the contender to do what the law requires him to uphold the power of the court, and also to secure the rights of the parties to a suit awarded by the court. There are kinds of contempt according to manner of commission. It is direct contempt as discussed in section 1 and indirect contempt in section 3. To differentiate, direct contempt in general, it is committed in the presence of or so near the court or a judge as to obstruct or interrupt the proceedings before it. And the following are acts constituting direct contempt. First, misbehavior in the presence of or so near the court as to obstruct or interrupt the proceedings before it. Second is disrespect toward the court. Third, offensive personalities towards other. Letter D, refusal to be sworn as a witness or to answer as a witness. E, refusal to subscribe an affidavit or deposition when lawfully required to do so. And F, acts of a party or a council which constitute willful and deliberate forum shopping, and G, unfounded accusations or allegations or words in a pleading tending to embarrass the court or to bring it into disrepute. While indirect contempt, this is discussed in Section 3 of Rule 71, indirect contempt is not committed in the presence of the court but done at a distance which tends to belittle, degrade, obstruct, or embarrass the court and justice. The following acts constitute indirect contempt. Letter A, misbehavior of an officer of a court in the performance of his official duties or in his official transactions. B, disobedience of or resistance to a lawful writ, process, order, or judgment of a court, including the act of a person who, after being dispossessed or ejected from any real property by the judgment or process of any court of competent jurisdiction, enters or attempts or induces another to enter into or upon such real property for the purpose of executing acts of ownership or possession given to the person adjudged to be entitled thereto. Letter C, any abuse of any unlawful interference with the processes or proceedings of a court not constituting direct contempt under Section 1 of Rule 71. And letter D, any improper conduct tending directly or indirectly to impede, obstruct, or degrade the administration of justice. E, assuming to be an attorney or an officer of a court and acting as such without authority. F, failure to obey a subpoena duly served, and G, the rescue or attempted rescue of a person or property in the custody of an officer by virtue of an order or process of a court held by him. Further, in Section 3, it's cited that nothing in this section shall be so construed as to prevent the court from issuing process to bring the respondent into court or from holding him in custody pending such proceedings. The proceeding for direct contempt, as cited in Section 1, it is summary in nature. And the punishment for direct contempt, the first one is regional trial court or court of equal or higher rank, the fine not exceeding 2,000 or imprisonment not exceeding 10 days or both. And for MTC, fine not exceeding 200 or imprisonment not exceeding 1 day or both. If contempt consists in the refusal or omission to do an act which is yet within the power of the respondent to perform, he may be imprisoned by order of the court concerned until he performs it. The remedy for direct contempt is provided in Section 2, Rule 71. First, he cannot appeal, but he may file certiorari or prohibition under Rule 65. And second, execution of judgment shall be suspended pending resolution of the petition, provided that the two requisites shall be complied with. The first one is he files a bond fixed by the court which render the judgment, and condition that he will abide and perform the judgment should the petition be decided against him. While the grounds for for indirect contempt was already mentioned in section 3 earlier, and the proceeding for indirect contempt, it is punished after charge in writing has been filed and an opportunity given to the respondent to comment thereon within such period as may be fixed by the court.
Everyone. So to continue, I'll be discussing section 4, 5, 6 of the Rule 71. So for the section 4, so how proceedings commence. So there are two modes of commencing proceedings for indirect contempt. So first, motu proprio by the court through an order or any other formal charge requiring the respondent to show cause why he should be not punished for contempt, and the other one through a verified petition charging for indirect contempt with supporting particulars and certified true copies of documents or papers involved therein, and upon full compliance with the requirements for filing initiatory pleadings for civil actions in court concerned. So, the next for the requisites before accused may be punished for indirect contempt. So, there are three. So, the following are charged in writing to be filed or a show cause order issued by the court, and the opportunity per person charged to appear and explain his conduct. And based on Regalado versus Co, so to be heard by himself or by counsel. So, our charge is to be filed. So, under Rule 5, under Rules 71, Section 5 of the Rules of Court, where the charge for indirect contempt has been committed against a regional trial court or a court of equivalent or higher rank, or against an officer appointed by it, the charge may be filed with such court. And where such contempt has been committed against a lower court, the charge may be filed with the RTC of the place in which the lower court is sitting, but the proceedings may not be instituted in such lower court, subject to appeal to the RTC of such place in the same manner as provided in Section 11 of this rule. So, in consonance with bar matter number 803, so for the recorrections of clerical errors and adoption of amendments to 1997 Rules of Civil Procedure, which were approved on April 8, 1997, effective July 1, 1997. So, the court resolved to correct the following provisions in the 1997 Rules of Civil Procedure under Section A or Paragraph A, Section 3 of the Rule 30, and Paragraph B, Section 5 of Rule 71. So, under Section 6, for the hearings or hearing release on bail, so if the hearing is not ordered to be had forthwith, the respondent may be released from custody upon filing a bond in an amount fixed by the court for his appearance at the hearing of the charge. On the day set, therefore, the court shall proceed to investigate the charge and consider such comment, testimony, or defense as the respondent may make or offer. And here, may the respondent in direct contempt held in custody be released in bail? So, yes. So, if the hearing is not ordered to be had forthwith, the respondent may be released from custody upon the filing of a bond in an amount fixed by the court for his appearance at the hearing of the charge.
Section 7. Section 7 talks about the punishment for indirect contempt. So, what is the punishment for indirect contempt? The punishment for indirect contempt depends upon the level of the court against which the act was committed. If respondent is adjudged guilty of indirect contempt committed against a regional trial court or a court of equivalent or higher rank, he or she may be punished by a fine not exceeding 30,000 pesos or imprisonment not exceeding 6 months or both. If the respondent is adjudged guilty of indirect contempt committed against a lower court, the punishment will be a fine not exceeding 5,000 pesos or imprisonment not exceeding 1 month or both. And if the contempt consists in the violation of a writ of injunction, temporary restraining order, or status quo order, complete restitution to the party injured by such violation of the property involved or such amount as may be alleged and proved. May a writ of execution issue for the enforcement of a judgment imposing a fine? Yes, the writ of execution, as in ordinary civil actions, shall issue for the enforcement of a judgment imposing a fine unless the court otherwise provides. And that's pursuant to Section 7 of Rule 71. When imprisonment shall be imposed? When the contempt consists in the refusal or omission to do an act which is yet in the power of the respondent to perform, he may be imprisoned by order of the court concerned until he performs it. So, under Section 8 of Rule 71, the imprisonment may exceed more than 6 months. And the reason for indefinite incarceration in civil contempt proceedings in proper cases is that it is remedial, preservative, and coercive in nature. The punishment is imposed for the benefit of a complainant or a party to a suit who has been injured. Section 9 of Rule 71, proceeding when party released on bail fails to answer. Under this section, the court may issue another order of arrest or may order the bond for his appearance to be forfeited, confiscated, or both. And if the bond be proceeded against, the measure of damages shall be the extent of loss or injury sustained by the aggrieved party by reason of the misconduct for which the contempt charge was prosecuted with the costs of the proceedings. If there is no aggrieved party, the bond shall be liable and disposed of as in criminal cases.
Good evening. I'll further discuss Section 10 of Rule 71. Section 10. Court may release respondent. The court which issued the order imprisoning a person for contempt may discharge him from imprisonment when it appears that public interest will not be prejudiced by his release. In the case of Inuturan versus Lemsiaco Jr., the Supreme Court clarified that it is only the judge who ordered the confinement of a person for contempt of court who can also issue the order of release. Section 11, Remedy against indirect contempt and its penalty. A person adjudged in indirect contempt may appeal from the judgment or final order of the court in the same manner as in criminal case. The appeal will not, however, have the effect of suspending the judgment if the person adjudged in contempt does not file a bond in an amount fixed by the court from which the appeal is taken. This bond is conditioned upon his performance of the judgment or final order if the appeal is decided against him. In case of Ang versus Bitanga, the court held that rule in criminal cases which prohibits acquittals from being appealed became apt in contempt proceedings with respect to decisions in dismissing charges of contempt. Because appeal from the judgment or final order follows the same principle as in criminal cases, if appellant is declared not liable for indirect contempt, the adverse party cannot appeal following the rule in criminal prosecution on double jeopardy. Section 12. The rules on contempt apply to contempt committed against persons or entities exercising quasi-judicial functions or in case there are rules for contempt adopted for such bodies or entities pursuant to law. Rule 71 shall apply suppletorily. The regional trial court of the place where contempt has been committed shall have jurisdiction over the charges for indirect contempt that may be filed. Examples of quasi-judicial bodies with contempt powers. First is the National Labor Relations Commissions and Labor Arbiter. Second is Housing and Land Use Regulatory Board. And third, in exercise of quasi-judicial powers, the Department of Agrarian Reform. With regard to the manner of contempt against quasi-judicial bodies depends on, first, if there is a statute that grants such quasi-judicial bodies or officers contempt powers, they can hold the offending party or parties indirect contempt without need for judicial recourse. Second, if there is no statute that grants such quasi-judicial bodies or officers contempt powers, they may hold the offending party or parties in indirect or direct contempt in the proper regional trial court. For example of Section 12 of Rule 71, we'll discuss briefly the case of Spouses Rodriguez versus HLURB. For the summary of the case, the spouses Nicolas filed a case against the spouses Rodriguez for the latter's closure of subdivision road lot. HLURB rules in favor of spouses Nicolas. The spouses Rodriguez sought to set aside the HLURB's decision by way of petition for certiorari with Court of Appeals. The CAA dismissed the petition and spouses Rodriguez appealed before the Supreme Court for petition for review on certiorari under Rule 45. Spouses Nicolas filed a petition for indirect contempt against spouses Rodriguez, alleging that despite vigorous protestation on the part of spouses Nicolas and with a cease and desist order issued by the HLURB, spouses Rodriguez incomplete injunction issued by the HLURB continuously, maliciously, and feloniously dumped filing material that would block the road load leading to the inner lots of the Ruben San Gabriel subdivision. The court cited Section 12, Rule 71 of the Rules of Court, which provides that contumacious acts committed against quasi-judicial bodies such as HLURB, the regional trial court of the place where the contemptuous acts have been committed, and not the Supreme Court that acquires jurisdiction over the indirect contempt case. Although the decision of the quasi-judicial body is pending appeal before the Supreme Court, the jurisdiction over the petition for indirect contempt committed against the quasi-judicial body is still with the regional trial court. For the doctrine of this case, Section 12 of the Rule 71 of the Rules of Court states that with respect to contumacious acts committed against quasi-judicial bodies such as Housing Land Use Regulatory Board, the regional trial court of the place where the contemptuous acts have been committed that acquires jurisdiction over the indirect contempt case. That's all for our report. Thank you for listening.